Hi, everyone, and welcome to Legally Speaking with Victor Guam. I'm Victor Guam, a legal practitioner with over 35 years of experience arguing cases at all levels of court in Nigeria. This podcast is a passion project born from my deep love for the law and the countless insights I've gathered along the way. Whether you're a lawyer, law student, or just curious about how the legal system works, you're in the right place. Let's dive in. Disclaimer: Legally Speaking with Victor Guam is for informational purposes only and does not constitute legal advice. All cases and issues discussed are based on public domain materials. The views expressed are those of the host and guests and do not represent any organization. All content, including audio, branding, and materials, is the intellectual property of Victor Guam and may not be used or reproduced without permission.
Okay, let's unpack this. Have you ever been in a situation where you felt like you absolutely had to have a say in something, only to find out the door was, well, already closed? Maybe a decision was made, you weren't even in the room, but it totally impacted you.
Yeah, that feeling.
That feeling of being unfairly left out, especially after a court judgment has already been made, I think feels intuitively wrong. Right?
Yeah, it really does.
Yeah.
But, the world of law has these incredibly precise rules for who gets to speak and when and how.
Right.
And that precision is exactly what we're drilling into today. We're taking a deep dive into a really telling case from the High Court of Lagos State, a ruling from November 9, 2021.
Okay.
It's a perfect example, really, that illuminates a fundamental principle of legal procedure, what it actually means to be a party to a suit, and why court decisions, once made, carry such significant weight.
The finality of it all.
Exactly. We'll be looking at the specifics of Suit No. M2337 P17 and what this particular legal battle tells us about who has the right to challenge a case that's already, concluded.
So our mission today is to unravel this fascinating legal puzzle. You'll discover why, in the courtroom, knowing when and how to speak up can be far more important than maybe even what you want to say.
That's a key point.
We're going to break down the key arguments, try to understand the judge's meticulous reasoning, and see what the court ultimately decided. You'll walk away understanding the very distinct and often quite strict paths available to someone affected by a judgment, even if they weren't initially named in the suit. It's kind of a masterclass in legal standing and why timing really is everything.
Absolutely. Timing and procedure.
All right, let's zoom in on the specific details of this legal drama. This case, presided over by the Honorable Justice M.A. Savage, it centers around the estate of Dr. Chief Oluyinka Olumide, now deceased.
Okay.
The original judgment that really kicked all this off was delivered way back on May 2, 2018, so quite a while before this later challenge.
Right, years before.
And this earlier ruling involved the executors of the estate, Chief Theophilus Oluwole Akindele and Prince Francis Gibadebo Adewale. They were the judgment creditors.
The ones who won the judgment, essentially.
Yes. And on the other side was the probate register of the High Court of Lagos, basically the court official dealing with wills and estates as the judgment debtor.
Got it. So what's really crucial here is that the initial matter was a concluded suit. It concerned the administration of that deceased estate. It had gone through its process. A judgment was delivered. Done deal,
Seemingly.
And this sets the stage for the dramatic challenge that came much later from someone who wasn't originally a named party to that 2018 judgment. It's like a book had been closed only for someone to try and pry it open again.
But then, the quiet finality of that 2018 judgment was shattered almost 2.5 years later.
2.5 years.
Yeah. In what many might see as a bold, maybe unexpected move, a new player emerged. Mr. Olusunmade Olumide, a beneficiary of the very same estate.
Ah, beneficiary.
Okay, he filed what's called a motion on notice, dated August 12, 2020. He saw himself as an interested party respondent, and wow, he was trying to achieve a lot with this single motion, wasn't he?
He certainly was. It really makes you wonder, what exactly was this interested party trying to achieve, especially after so much time had passed? His application was quite ambitious, containing 5 key requests, or prayers as they're called in legal terms.
5 prayers. What were they?
Okay, first, he wanted to be joined as a defendant in the existing, the concluded cause.
Okay, jump into the old case.
Second, he sought to set aside the original judgment of May 2, 2018, and all proceedings leading up to it. Now, his grounds were serious. claiming it was obtained by suppression of material facts and by fraud, and also for want of jurisdiction.
Fraud and lack of jurisdiction, those are big claims.
Huge. Third, he requested the joinder of two other beneficiaries, Dr. Mrs. Bimbola Holloway and Dr. Olin Rawaju Olamite.
Bring more people in.
Fourth, he also sought the joinder of an entity called Sun and Wyland Shopping Hall Enterprises.
Interesting. Another party.
And finally, number 5, he wanted to stay, halt, nullify, or revoke the letters of administration that had been obtained. Those are the official documents giving someone legal authority to manage an estate.
Right, the executor's authority.
Exactly. And nullify any steps taken to fulfill that 2018 judgment.
Oh.
Basically, rewind everything.
Wow. So if I'm understanding this correctly, his core belief was that because he wasn't explicitly named, wasn't joined in the original suit, the court somehow lacked proper jurisdiction. And therefore, the whole thing, the entire judgment, should just be thrown out, nullified.
That seems to be the crux of it.
He even argued that as a beneficiary, he was sort of a party by implication because, you know, the executors are supposed to act for the beneficiary's benefit.
Common argument, that one.
And on top of that, he's alleging fraud and suppression of facts. It really sounds like he felt genuinely wronged and left out.
You can see why he'd feel that way, from his perspective.
Well, as you might imagine, the original judgment creditors, Chief Akindele and Prince Adwal, they didn't just sit back and let this happen.
Not likely.
They quickly filed what's known as a notice of preliminary objection, basically trying to stop Mr. Olamide's motion right there before it even got going.
A preemptive strike, procedurally speaking.
Exactly. Their core argument was pretty straightforward, yet fundamentally important. Mr. Olamide simply didn't have the legal right, or locus standi, to bring such a motion.
Locus standing, the right to be heard by the court.
Yes. And if he didn't have that standing, the court couldn't even consider the merits of his claims about fraud or jurisdiction or anything else.
Right. The objection was about his right to even ask, not necessarily about whether his underlying complaints were valid. And their grounds for objection were very specific, and they really formed the absolute crux of the court's later analysis.
Okay. What were those grounds?
Well, first, as you said, the interested party lacked locus standing to seek these prayers. It's not enough just to feel impacted. You need to recognize legal connection, a specific standing.
So just being a beneficiary wasn't automatically enough for this type of application?
Apparently not for trying to reopen a concluded case in this way. Second, they argued, quite simply, a non-party cannot be heard in this court in this manner. You can't just walk in off the street, so to speak.
Yeah.
Third, and this is crucial, they asserted that the non-joinder of a party, meaning someone not being included, does not, in itself, affect a court's jurisdiction or competence to hear and enter judgment.
Ah, okay, that directly contradicts his main argument.
Directly. And they pointed out this is a very common misconception outside of legal circles. Fourth, they contended that the interested party's procedure, this whole motion, was strange and unknown to law, making the application itself incompetent.
Strange and unknown to law sounds harsh.
It's strong legal language indicating a serious procedural flaw. And finally, perhaps most critically, they argued that since judgment was delivered way back on May 2018, the court became functus officio.
Functus officio? Okay, that's a legal term many listeners might not be familiar with. Is that like saying the judge has, I don't know, signed off, closed the book on that specific case and moved on?
Precisely. That's a great way to put it. Once a trial court delivers a final judgment on the merits of a case, its specific authority over that particular case is essentially spent. It's done its job.
Its function is finished.
Exactly. Functus officio function performed. Any further action, like challenging the judgment, generally needs to happen at a higher level, like through an appeal to a higher court. It's a crucial principle that ensures finality in litigation. You need cases to actually end at some point.
Makes sense. Otherwise, it could just go on forever. So the judge in this case had to weigh these really conflicting arguments. You've got the interested party feeling wronged, alleging fraud, lack of jurisdiction, and you've got the original winner saying, hold on, the case is closed and you don't even have the right to be here asking this.
A classic procedural standoff.
And her ruling laid out this fascinating roadmap showing exactly how these long-standing legal principles get applied in a real-world dispute. She started, logically, with a fundamental question. Who is considered a party to an action in the first place?
Yeah, back to basics. And what's truly fascinating here is how clearly the apex court, the highest court, has defined party. The judge, referencing a landmark case, Effie Hunme v. NBA, N01, she reiterated that a party is a person whose name is designated on record as a party.
So, literally named in the paperwork.
Yes, that person by or against whom a legal suit is sought. And the law is what we call trite, meaning it's so fundamental and well-established, it's almost like a legal axiom.
Taken as read.
Exactly. It's trite law that only parties to a suit can make applications in the suit. The judge looked at the record and noted, quite simply, the interested party, Mr. Olamide, was not named as a party to the original 2018 suit.
Plain and simple on the record.
Plain and simple.
And it sounds like trying to bring in an application as a non-party is just a big procedural misstep, right? You mentioned she cited another case.
Yes, J.A. Tola Property Development and Investment Co., LTD and Rs via Sawandi and Rs. In that one, the Court of Appeal described a non-party trying to bring an application against existing parties as strange and unknown to law.
There's that phrase again.
It really hammers home the importance of following the proper established legal channels. You can't just invent your own way in. And then there was the critical question of when he tried to do it. Even if he had standing, could he bring an application to join a suit that was already concluded?
Right, the timing issue.
Exactly. And the Supreme Court, in another case, Odito vs. PDP, has already settled this quite clearly. It stated unequivocally that it's improper to file an application for joinder as defendant after delivery of judgment.
So once the final whistle blows, you can't ask to be subbed in.
That's a good analogy. If we connect this to the bigger picture, it just underscores the principle of the finality of judgments. It's absolutely essential for legal certainty in any system.
Right.
Otherwise, like we said, cases would never truly end.
But I can still imagine many listeners thinking, but wait, if he's a beneficiary of the estate, isn't he implicitly part of the estate's legal matters? What about his main argument that the judgment should be set aside because he wasn't joined and that this somehow affected the court's basic authority, its jurisdiction? That feels like a powerful argument from just a common sense perspective.
It's a very common and, frankly, understandable thought process. Why wouldn't a beneficiary have a say? But the law, for reasons of procedure and finality, draws a very clear line here.
Okay.
The judge addressed this head-on. She cited Okoye vs. NCEC, where the Supreme Court held, and this is key, that failure to join a necessary party is an irregularity which does not affect the competence or jurisdiction of the court to adjudicate the matter before it.
An irregularity, not something that kills the whole case.
Exactly. It might lead to unfairness, and perhaps a judgment could be set aside on appeal, meaning a higher court reviews it and decides the non-joinder was critically unfair.
Ah, so appeal is the key word there.
Yes, but it doesn't automatically make the trial court's judgment a nullity, and it doesn't give the trial court the power to review its own final judgment after it's become functus officio.
So the trial court can't undo its own final decision just because someone pops up later saying they should have been included.
Generally, no. And another landmark case, Bello vs. Ines, further clarified that failure to put a non-party on notice isn't fatal to the court's jurisdiction or a ground for nullity, especially when no specific relief was actually claimed against that non-party in the initial proceedings.
Okay, that makes sense. If the original case wasn't asking for anything from Mr. Olamide, maybe the need to join him wasn't seen as essential to the court's power to decide the matter between the executors and the probate registry.
That seems to be the legal logic, yes. It's about respecting the system's own rules of the game, even if those rules sometimes feel a bit counterintuitive when you look at fairness from a purely personal angle.
So for our listeners, if you find yourself in a situation like this, you're an interested party, you weren't involved in the original suit, but you feel genuinely affected by the judgment, what is the correct, legally recognized path to take? You can't just file a motion in the old case.
Generally, no. The judge clearly stated the proper option. The remedy of an interested party who was not a party to the suit in which judgment has been delivered, but claims he is affected by the judgment, is to appeal the judgment.
Appeal. Go to a higher court.
Precisely. It means filing a separate action in the Court of Appeal, asking them to review the original decision. You'd likely need to apply for leave, for permission, to appeal as an interested party.
So there's still a process.
Oh, absolutely. It's not automatic, but that is the designated legal pathway. Not trying to reopen the concluded case at the trial court level. It's a tough lesson for many who aren't familiar with court procedures. You can't just knock on the trial judge's door after the party's over, hoping to get things changed. You must pursue your rights through the established framework.
even if that means starting a whole new process at a higher level.
Yes.
And what about those strange applications that don't fit the rules, like the one Mr. Omide filed? What did the judge say about trying to innovate procedure like that?
Well, the judge, quoting another case, Mobile Producing, NAGN Ltd vs. Monopeo, underscored that while legal innovations are welcome, they must conform to the existing rules of procedure.
Rules are rules.
If an innovation conflicts with the rules, they must give way to the rules. And a court process that is not known to law is considered null and void ab initio, meaning it's invalid from the very beginning, as if it never even happened.
Wow. So the way he tried to challenge it was fundamentally flawed from the start, according to the court.
That's what the judge found. She also cited principles from cases like N.A. Williams vs. HRVFS, which confirmed that only an actual party to the suit can apply to set aside the judgment of that suit at the trial court level.
Okay, so after carefully considering all the arguments, looking at all these established precedents, the judge delivered her final ruling, and it sounds like it was quite definitive, wasn't it?
It was very clear. In totality, the presiding officer found absolute merit in the arguments raised in the preliminary objection, the arguments against the interested party's application.
So she agreed with the original judgment creditors.
Yes. The judgment delivered way back on May 2, 2018 was sustained. It stood. And the application dated August 12, 2020, filed by the interested party, Mr. Olamide, was struck out.
Struck out, not dismissed on the merits of his fraud claims, but struck out because he didn't use the right procedure or have the standing to bring it in that way.
Exactly. It was struck out on procedural grounds based on the preliminary objection. The court didn't even need to delve into the substance of his allegations of fraud or suppression of facts because his application itself was deemed incompetent.
So this means the court firmly upheld the principles of locus standi, the finality of judgments, functus officio, and the absolute importance of adhering to proper procedural channels when challenging court decisions.
Precisely. It reinforces that even with a strong personal interest, even if you feel deeply wronged, the legal system demands a very specific approach. You have to play by his rules.
It's a powerful illustration of how procedure can sometimes be just as important, if not more so, than the substance of a complaint.
Absolutely. What we've really learned from this deep dive is the critical importance of legal standing, having that recognized connection to a case, and this concept of functus officio in a court of law. A court, once it has delivered a final judgment on the merits, has fulfilled its function for that specific matter. Its job is done there.
Right.
And while individuals, like beneficiaries, may genuinely be affected by judgments they weren't formally part of, the law provides a very specific remedy, usually, an appeal, not a do-over or a reopening of a concluded case at the trial level. It's all about respecting the chain of authority and the finality that's necessary for a functioning, predictable legal system.
So what does this all mean for you listening? Next time you hear about a legal case, maybe consider not just the outcome, the headline, but the meticulous process behind it. Think about the very specific roles and rights of those involved. How might knowing these strict procedural rules like locus standi and functus officio change your perspective on legal fairness, or the paths that are actually available for recourse?
The different lens to view things through.
It really is. It's a powerful reminder that in the eyes of the law, not everyone can simply walk into a concluded matter and demand it be undone, no matter how interested or personally affected they might feel. It really is about navigating the system correctly, understanding its boundaries, and choosing the right legal door to knock on. What stands out to you about these often quite rigid rules?